Hmm. Saya share screen lah sebab kadang-kadang bila kita navigate, saya navigate selalu saya tengok seorang-seorang, saya tengok saya tak perasan benda tu satu-satu. Okay, so saya share screen ya. Okay, bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alright, so if we start with goals, if you look at goals, there are some topics, actually it is been there before. Tapi saya susun balik sajalah ya. It's matters pursuant to winding up. Okay, Cik Azmi cover part ni compulsory winding up. So sebelum ni, before we started on the compulsory winding up, we have had the voluntary winding up this part kan. So we have finished this. So berapa ramai yang jawab quiz ni? Quiz on voluntary winding up is part of your tutorial. So I hope you can you have answered the question. Okay, and then Cik Azmi will finish the compulsory winding up. So basically on the part of the procedure, procedure relating to the process in court, for the court to give order for a company to be wound up. So yang tu kita panggil compulsory winding up because it involve court. The court give the order. So that is the reason why it is considered as, ataupun it is termed as the compulsory winding up. Okay, so I hope today Cik Azmi akan finish about the petition yang dekat sini ni, petition. Okay, and then petition sama dengan basically dia exactly ataupun almost similar dengan dengan bankruptcy petition, dan dia ada affidavit juga, affidavit verifying the truth of the petition. Affidavit menentu sahkan petition. So both process tu similar. Dia akan ada proses macam delivery, service of the document to the company. So kalau bankruptcy tu kepada orang tu lah, orang yang the debtor, the judgment debtor. Tapi kalau winding up tu, it's the subject matter tu is the company. So the process tu is the service to the company. Semua proses iklan apa semua, cuma dia lebih proses iklan tu lebih kompleks compared to the bankruptcy. Okay, nanti kita tengok Cik Azmi punya explanation about the petition, the affidavit, the process for the advertisement as well. Alright, for today, I would like to cover the matters pursuant to winding up. So what happened, for example, it comes from the, contohnya, voluntary winding up juga. Lepas je company tu has been wound up, what happened? So when it commence, when the winding up, ataupun winding up of the company tu started, when is it? So what is the effect of the winding up? Okay, and then what is the process after that? Till the end ataupun the company cease to exist. Sebab dia dekat sini macam proses tu more or less similar with the bankruptcy. Cuma kalau yang macam company tu, dia maksudnya dia tamatkan company tu. Maksudnya at the end of the process is the deregistration. Kan sebelum ni the process of incorporation of the company, that is the company tu is to be registered in the register of the company kan, ROC kan, ROC. Sorry, tu yang tu registrar of company kan, tapi it's a kind of macam register which is maintained by the ROC. Okay, so that is the process of incorporation of the company. So bila a company has been wound up, so that means the company would be deregistered. Maksudnya dia tamat lah, maksudnya dia punya life as a legal person tu has been ended by the process of winding up. Okay, so we are going to look at what happened after this. So the first topic is commencement of winding up, when the winding up commence. So kemudian apa effect dia of the commencement of the winding up. Okay, and then we will look at how the liquidation process is conducted. Okay, and then liquidation process tu yang mengendalikan dia, the person who conduct or manage the liquidation process tu is liquidator. Okay, so dekat sini yang kita panggil perkataan liquidation tu. So winding up is the process to wind up a company. So liquidation is the process when the company is wound up. So that is the liquidation process. Okay, then kita tengok sikit je sebab bab ni sama dengan bankruptcy, application of company asset. So the distribution of company asset tu macam dia punya priority of the order. ataupun the distribution of the asset tu is to be given to whom first, okay, at the end to whom. So sama macam dengan bankruptcy, last kali adalah dia punya unsecured creditor. Okay, kita tengok baru balik pada yang unsecured creditor tu adalah yang last kali. Kemudian kalau ada balance baru pergi dekat members of the company. So sama dengan bankruptcy process. So yang dekat last ni kita tengok go through sikit je. Okay, so we start with the commencement of winding up. So semua ni ada dalam goal So you can have a look after this Okay, so this is the slides I prepared for the commencement of winding up and what is the effect of it. So the question is the time when does winding up commence? So okay tak kalau saya tak buka full slide macam ni? Okay tak?
Boleh
dia macam tahu sikit saja.
Saya
apa dia?
Macam
full slide boleh?
Suka besarkan?
Betul sebab tak nampak saya pakai
sikit.
phone.
Alright. Okay, ada yang
Thank
pakai
you.
phone Alright. Okay, so kita besarkan yang ni duduk sini. Okay, so this talk about the point of time when the winding up commence. This is important because there are certain transaction which cannot be made by the company. So that is the reason why the time of the commencement of the winding up is important. Okay, so untuk setiap proses ni dia ada semua kita akan patah balik pada voluntary winding up dan juga compulsory winding up. Okay, as to voluntary winding up, VWU tu is V tu is for voluntary So remember about voluntary winding up, the process in which the members of the company ataupun the director of the company started the process ataupun the creditor of the company started the process. Kan dia akan boleh jadi the members voluntary winding up ataupun creditors voluntary winding up. Tak kisah mana-mana satu lah yang tu. Okay, and then the other one is the compulsory winding up here, that is by card. Okay, so as to the voluntary winding up, it commences. So in situation where an interim liquidator has been appointed before the resolution for voluntary winding up is passed, the time of the commencement is on the date of the director's declaration of the company's inability to carry on its business. So yang ni untuk apa? Yang ni what kind of voluntary winding up? Yang mana interim liquidator has been appointed? You remember? So which one? Members or creditors?
Creditors.
That's right. So creditors, this is the situation when the company is insolvent. Okay, and then the creditor, the directors declare, make a statutory declaration that the company is unable to pay is that. So in that situation, the only way to be made by for the winding up is to be made by the creditors. Okay, so yang A ni bila ada interim liquidator that is on the date of the declaration itself. Okay, so dia dah start dekat situ. Walaupun sebelum meeting of the company to resolve for the company to be wound up. Okay, so dia lagi awal lah maksudnya dekat sini. Okay, so in any other cases untuk when there is no interim liquidator appointed, so the winding up commence at the date of the passing of the resolution for voluntary winding up. So that means the date of the meeting. So which resolve for the winding up of the company. Okay, so that's the first. Okay, the second one in relation to the compulsory winding up. So the commencement of the voluntary winding up shall be at the date of the winding up order. So yang ni kita tak baca during the course of your study. Please read the provision as well. So if before the presentation of the winding up petition, a resolution has been made for voluntary winding up, the winding up of the company shall be deemed to have commenced at the time of passing of the resolution. So if for example, yang kat sini sebenarnya saya rasa macam it's not really ni lah, dia macam make clear the situation lah sebabnya sebelum presentation of the winding up petition tu tak ada order pun sebenarnya. Okay, tapi kalaulah dia adalah order tu, dia akan kalau ada, sebab bila dah ada voluntary winding up, so maksudnya at the time of the passing of the resolution tu the company has been deemed to be commenced. Dia punya winding up tu has been deemed to be to commence. Yeah. Okay, so that is the provision as to the time of the commencement of the winding up. So maksudnya dia start lah to diundap. Ya. Boleh? Okay, so next kita tengok apa dia punya effect. Implication. Yeah, implication of the commencement of winding up. So when the company cease, yeah, when the company is wound up, yeah, the company business has to cease. Yeah, so that is the first effect. Yeah, except, yeah, so that is the general provision. Semua implication kat sini adalah general provision. There are the situation in which it allow for the carrying on of its business. Yeah. So dia kata the company shall cease to carry on its business from the commencement of the winding up, except so far as is required in the opinion of the liquidator for the beneficial winding up. Okay, so that means when a company has been wound up, so the person who take over the management of the company is liquidator. Ya, nanti kita tengok topik tentang liquidator. Ya. Okay, so the liquidator may allow for the company to continue the business if it thinks it is good for the winding up. Contohnya macam business yang macam nak habiskan dia punya stok, for example, macam mungkin ada dalam gudang tu masih ada banyak lagi barang kan. So dia boleh continue. So because the company can collect money kan daripada situ, dia dapat profit, for example. So dia macam ending the business only. Dia tak boleh macam order barang baru apa semua yang tu tak boleh. Tapi just for the purpose of ending the business because it would be good for the winding up process itself. That is macam for the purpose of paying the creditors debt at the end lah. So that is the ultimate purpose of it. Yeah. Okay, so there is a macam specific situation if the company is wound up by the court, the liquidator yang second the liquidator may carry on the company's business so far as is necessary in favor of all the creditors and contributories of the company. I hope you still remember who are the contributories of the company. Yeah, so they are commonly members of the company yang undertake to pay ataupun undertake the liability of the company to certain extent lah. Dia limited lah dia punya contribution. Yeah, bila a company has been wound up. Okay, so dia punya tempoh tu given is the 180 days after the date of the winding up order. So dia ada tempoh dia lah. So dia tak adalah boleh sepanjang masa for the purpose of the compulsory winding up. So later, so kalau dalam tempoh selepas 180 hari dia tak 180 hari berapa bulan? 3, 6, 18, 6 6 bulan kan? Betul? Saya kira. Okay.
Betul.
Alright. Okay, so kemudian, so after that, so the liquidator must obtain the authority of either the court or the committee of inspection. So yang ni kalau committee of inspection tu if it is established to continue with the business of the company. Okay, so the carrying on of the business tu is limited to end the business. Dia tak boleh nak resuscitate the company. Macam contoh dia tak boleh nak hidupkan balik. Tak adalah bila dia continue the business tu in order to rescue the company. So it's over already. So they can no longer revive the business. Mungkin dia tak boleh lagi kalau macam ada stok dah nak habis, dia tak boleh cari stok baru, for example. So dia tak ada power, dia kata kat sini, the liquidator has no power to carry on the business with a view to resuscitate the company or making profit. By this time it is too late for that. However, the corporate state and corporate powers of the company shall continue until it is dissolved. So that means dia punya power of the company tu is stated in dia punya memorandum and article of association kan. The power to, for example, to sell kan, the power to to transfer, the power banyak lah kan, dia punya senarai itu panjang kan. So basic idea is that they still have power to do something, to do the powers as provided under their memorandum and articles, until it is dissolved. Okay, so that is the first effect, cease of business. Kenapa saya klik tak mau? Okay. Okay, second one is the cessation of the director's power. So upon winding up, so the person who take over is the liquidator. So the director can no longer continue to operate. Yeah. Okay. Okay, except, sama je juga kat sini except if the liquidator approve, for example, there are certain situation in which if the liquidator feels that the director has to function, so it must be subject to the liquidator's approval, So the board of directors become functus officio, dipanggil. Functus tu maksudnya dah tak berfungsi lagi, Okay, so that is the next effect of the winding up. Okay, and then next effect is that disposition ataupun any transfer of the property would be void except in certain situation. General idea is that any disposition of the property, dispose of to jual, transfer, disposition of the property of the company after the commencement of the winding up is void. So that is the general principle. So unless with the liquidator sanction, so kalau contohnya the company itu mungkin director ke jual harta dia apa semua, without the knowledge of the liquidators, it could not be done. It is void. So it could not be done on the part of the company. So the only person who can do that is the liquidators or the sanction of the liquidators. So this include the transfer of shares, alteration in the status of the members of the company. So this cannot be done except with the approval of the liquidators. Okay. So that is the third implication. So sebab apa dia kata? Sebab apa it cannot be done. So sama dengan bankruptcy juga kan. So bila dah start dia punya act of bankruptcy itu, dia punya yang doctrine of relation back apa semua tu kan. So dia tak boleh nak transfer harta dia. Sebab dia will frustrate the aim or the purpose of the proceeding of the winding up. Okay, so kat sini adalah satu case yang explain the process here. So dia kata it is a basic concept of our law governing liquidation of insolvent estate, whether in bankruptcy or under Companies Act, samalah kedua-duanya, that the free asset of the insolvent at the commencement of liquidation shall be distributed ratably, so maksudnya according to the law lah among the insolvent unsecured creditors at that date. So maksudnya kalau ada transfer for example being made on behalf of the company, selalunya intention dia adalah to frustrate the claim of the creditors. So this cannot be done. Okay, so sama dengan bankruptcy. So kita pass je lah Okay, meaning of disposition. Apa maksud disposition which is not allowed? Dia kata include transfer of the portion of the company's land, dalam case ni, and then transfer of property of the company, and then payment of money by the company, is all of these are considered as disposition. Sama dengan perkataan disposal, dispose of. So apa-apa cara lah untuk keluarkan harta of the company is considered as disposition. Okay, however, payment of money under an obligation already incurred or accrued. For example, dia ada debt yang memang dia bayar bulan-bulan contohnya, so it is allowed under the law. So it does not amount to disposition of property under the provision because it is part of the obligation which is incurred by the company under an existing contract. Okay, so that is the disposition. Okay, so basic idea is that disposition of property of the company is not allowed except with the sanction of the liquidator. Okay, so that is the third, the third one. Okay, yang ni tentang date of transaction. Dia kata the date of disposition is the date of the transaction. Ni sajalah So contohnya kalau date of the transaction tu is subsequent to the date of the commencement of the winding up. Contoh kalau dalam creditors voluntary winding up ada interim liquidator has been appointed dan transaction tu dibuat selepas tu, then the transaction tu be void. So that is why it is important to know when is the commencement of the winding up. Okay. Alright. So there is also a provision which allow for the court to validate a particular transaction which is made subsequent to the commencement of the winding up. So yang ni dalam section 472. Dia kata this is for particular to compulsory winding up. Dia kata there must be an application made to the court to validate disposition or transfer of the company's shares. So in situation when the disposition has been made after the order of the winding up being made, so still another way untuk avoid ataupun macam to validate, maksudnya tak mau dia jadi void, so is to make application to the court. Ni mungkin dalam tempoh transfer, for example, has been made, it has been already arranged, for example, for a certain transfer to be made. So the court may ataupun has power to validate the contract or the disposition of property. Okay, however, dalam air molek rubber company ni, dia kata the application should be made as soon as possible on the applicant being made aware of the winding up proceeding against the company. Okay, so time is important here. Dia tak bolehlah tunggu sampai mungkin lama-lama sampai winding up proceeding tu has been over, for example, before going to court in order to validate the transaction. Okay, so as soon as possible ni first matter of fact jugalah for the court to see whether it is reasonable, the time frame is reasonable or not. Okay, so that is about the disposition of the property which cannot be done except with the liquidator's sanction. Okay, so that is number 3. Okay, number 4, avoidance of undue preference transaction. Yang ni sama dengan bankruptcy juga kan. So any transaction which give preference to certain creditor, dia bayar certain creditor dalam certain tempo yang dalam section 528 tu is void. So it similar to bankruptcy proceeding, any undue preference transaction would be avoided. So kita tengok ayat dia, section 528 applies to both voluntary winding up and compulsory winding up. So any transfer, mortgage, so on and so forth yang kat sini, done by or against a company which is unable to pay its debt. So maksudnya dalam keadaan dia dah tak boleh bayar, okay, as the debt become due from its own money in favour of any creditor, shall be deemed to have been given such creditor a preference over other creditors. Okay, so any yang tadi yang disposition of property tu general to anyone, tapi yang section 528 ni undue preference, this is particular to the creditors. Okay, the timing is within 6 months from the date of making or doing the same, and every such act shall be deemed fraudulent and void. Okay, so that is the provision. So general idea is that any transaction yang macam bayar duit, transfer property, even mortgage, security macam signing of mortgage, providing security to the creditors would be void under the law, if it is made within 6 months. Okay. Alright, so that is the fourth implication of the law. So yang ni timing lah. Okay, saya rasa ni explanation sajalah. Okay, so yang ni the case tu is explain. The case ni explain the condition atau under section 5 to 8. Dia kata ni case tahun 1998 prior to amendment to section to Companies Act. Tapi dia sama dia punya provision tu. So dia kata there are 5 conditions under the law lah, under the provision. Dia kata the transaction took place within 6 months. So timing is important here. Prior to the commencement of the winding up. Okay, and then that it satisfy the description of one of the types of transaction mentioned dalam dalam section tadi tu dia kata tentang mortgage kan, sekejap ya. Yang ni transfer, mortgage, delivery of goods, ya, payment, ya, execution, so on so forth. Dia ada panjang lagi kat situ, saya pendekkan ya. So dia punya list of the transaction tu is mentioned ya, under 5 to 8 ya. Okay, and then the transaction took place at the time when the company was insolvent. Yeah, so the inability of the company to pay debt is important here. Okay, and then that the person in whose favor the transaction was effected was a creditor of the company. So kalau dia bagi ke orang lain, dia tak masuk bawah ni lah. Ya, dia masuk yang bawah disposition of the property just now. Yeah. Okay, and then number 5, the effect of the transaction was to confer on to that person a preference, priority or advantage over other creditors in the winding up. Okay, so that these 5 conditions must be satisfied, yeah, for the undue preference transaction to be void under the section. Yeah. Okay, so that is about the section tu tadi. Yeah. Okay, so yang ni kita boleh tengok kemudian lah ya. Okay, number 5, implication of the winding up is that avoidance of floating charges created shortly before winding up. Yeah, so generally floating charges cannot be created shortly before winding up. Kita tengok ini section 5 to 9. Floating charge created on property of the company within 6 months of the commencement of the winding up is void. So dia guna time frame yang sama, that is 6 months ya, prior to the commencement of the winding up. Okay, however, this exclude any cash paid to the company at the time and subsequent to the creation of the and in consideration for the charge together with interest at the rate of 5%. Yeah. Okay, kalaulah dia payment tu this is exception to the general rule kat sini lah. General rule is that floating charge which is created within 6 months prior to winding up is void. Okay, however, kalaulah dia kata the company tu, it can be proven that the company is solvent, yeah, macam dia boleh bayar hutang, so then it is allowed under the law. Yeah, it is valid under the law. Yeah. Okay, yang kat sini ni saya bagi explanation tentang apa tu floating charge ya, in case you do not mungkin sebab yang ni kita dah belajar dalam company law kan, apa tu floating charge. It is a security interest of a fund of changing asset. Asset tu contohnya macam stock ya. Saham contohnya, sebab saham dia berubah-ubah kan, dia punya nilai. Stock for example dia berubah-ubah ya. Stock tu stok yang dalam gudang contohnya, so dia berubah-ubah, dia punya nilai tu bergantung kepada masuk dan keluar barang tu lah ya. Okay, and then ataupun saham juga pun masuk juga ya kat sini. Okay, dia kata ada artificial person tu company lah which float or hover until the point at which it is converted into a fixed charge. Yeah? At which point the charge attached to a specific asset of the business. Okay, so that is the floating charge. Yeah? So it's a charge over something which is macam for the time being dia macam float until to certain time. Bila dia jadi macam fixed charge yang sama. So the point tu the point in which it is converted into fixed charge tu is deliberated ataupun arranged by the parties. Yeah? Okay, so that is general idea is that no floating charge can be created within 6 months prior to winding up, commencement of winding up. Okay. Okay, then number 6, no enforcement of execution. No enforcement or execution should be or kat situ should be. Okay, after the commencement of a winding up, any attachment of property of the company, sequestration, distress or execution put in force against the company is void. Yang ni execution for the judgment for example ataupun enforcement of debt of the company by creditors tu dah tak boleh buat lagi selepas commencement of the winding up. Yeah, so yang ni sama dengan bankruptcy juga. Yeah, so kalau contohnya macam dia ada dapatkan perintah mahkamah contohnya attachment order, dia panggil attachment of property before judgment for example. Yeah, yang ni part of macam perintah yang kita boleh dapatkan kalau kita rasa macam company tu is about to be unable to pay is that. So kita boleh attach dia punya property tapi kena dapatkan perintah mahkamah. However, when a company is wound up, bila dia punya winding up tu has commenced, dah start dah, kita dah tak boleh teruskan enforcement of the order of the court. So the only way is to put up macam proof of debt, sama dengan bankruptcy order juga, to the liquidator in order for the liquidator to pay back the debt. So that is the process. The process tu has to stop at the point of time when the winding up commence. Okay, so that is number 6. Apa yang tak boleh buat dia upon winding up. Okay, 7 is stay of action against the company. Okay, sama dengan bankruptcy juga kan. So when winding up of the company has commenced, so other creditors tu cannot proceed with a court proceeding against the company. Okay, tak boleh lagi masuk proceeding yang baru ataupun proceeding yang sedang berjalan tu dia stop. Dia stay, dia panggil stay, that is dia stop pending the winding up process ataupun liquidation process ya. Okay, so yang ni effect of the commencement of winding up. Apa yang tak boleh buat ataupun effect of a transaction which is made subsequent to the commencement of the winding up. So kita rapat balik. So the business has to cease except with the liquidator sanction. Okay, second, the director's powers come to an end. That is except with the sanction of the liquidators. Disposition of property is void. Okay, and then transfer of shares is void generally. And then alteration in the status of members of the company is also void. Yang ni kita discuss part of yang ni tadi. Avoidance of transfer of shares dan juga alteration in the status of members pun it cannot be done. Except with the sanction of the liquidators. And then there cannot be undue preference transaction to particular creditors. Okay, and then avoidance of floating charge. And floating charge cannot be created within 6 months prior to the commencement of the winding up. Okay, and then there is no enforcement ataupun if there is any action pending at the court, the action ataupun the proceeding will be stayed. Okay, so that's it for the topic of the commencement of the winding up and its effect. Okay, any question before we look at the other topic? Boleh tak? So do you have any questions? Saya tengok chat. Tak ada soalannya? Okay. So minta isi attendance ya. Pukul berapa? 9.40. Okay. So boleh continue. So kita tengok yang tadi kita tengok when the winding up commence, start, bermula dan apa effect dia. Okay, dan kita tengok apa proses lepas tu. That is the liquidation process. Liquidation process. What happened after that? So yang ni sama dengan yang bankruptcy. Bila the bankrupt person has been adjudged bankrupt. Okay, and then the person who take over to manage the property of the bankrupt person is the DJI kan, remember? Okay, tapi untuk company, the person tu kita panggil liquidator. So liquidator tu can be DJI, the insolvency department, dan dia boleh juga macam private liquidator. Selalu kalau yang macam voluntary winding up ni, biasanya yang appointed to manage the company as a liquidator is the private liquidator. Dipanggil qualified insolvency practitioner. So biasanya orang accountant ataupun auditor boleh apply untuk jadi apa dipanggil qualified insolvency practitioner. Yang tu nama dia is a professional punya professional job for this kind of process lah Okay, so basically the idea is if it is at the DJI, kalau compulsory winding up, banyak juga keadaan dia appoint the DJI as the liquidator, depending on the kadang dia punya, so depending on kalau macam voluntary winding up tu, yang ni compulsory winding up tu depending on the situation. So in most situation, untuk compulsory winding up, the DJI will be appointed as the liquidator. So we'll see what is the process for it. Yeah. Okay, untuk liquidation process, yeah. Okay, dekat sini baru kita panggil perkataan liquidation. Yeah. So dia ada basic idea, kita akan tengok tentang liquidator's role. Okay, and then the liquidator will conduct a meeting, final meeting for the company. Okay, and then the liquidator will manage for the dissolution of the company. So dia involve filing of the document dekat ROC lah. So basic idea. So kita tengok brief sahajalah tentang how it is made. Okay, we start with the members voluntary winding up. Saya besarkan yang ni. Okay. As to members voluntary winding up, it is macam more straightforward than other process. So the role of liquidator is a person primarily involved in undertaking all works in the course of the liquidation process until completion. So orang yang manage lah the whole things until the company comes to an end. Bila lepas dia wind up to the deregistration of the company. Okay, the liquidator will take possession, sama dengan bankruptcy, dia take, DJI take possession and realize the asset of the company and distribute them to the creditors. Yang tu aim process dia. The ultimate aim of the process is to pay back the creditors, dan kalau ada balance, dia akan bagi balik kepada members of the company. Okay, and then the liquidator is to undertake assessment and review what assets can be realized and what other recoveries can be made. So maksudnya dia investigate lah kat mana harta company tu. Kalau if needed to recover, contohnya macam company yang dah ni banyak mungkin harta-harta dia mungkin dah has been wrongly transferred, for example, to other person. So the process of recovery of the property itu has to be made by the liquidator. Okay, then to conduct administrative process, report and dealing with the relevant government department. Okay, ini biasalah Untuk administration tu kena file report, kena filekan form with ROC, with the other government department which are related to the management of the company. Okay, then to convene a general meeting of the members of the company if the liquidation process takes more than 1 year. If it is more than 1 year, okay, then to lay before the meeting an account of his act and dealing of the conduct of the winding up. So it can take years in order for the whole process to be over. Okay, then the last one is to convene a final meeting for the company before the company is to be dissolved. So that's the role of the liquidator, and this is actually the process itself. Process of the liquidation itself. Okay. Bila semuanya proses tu has been made, the final meeting tu is important, provided by section 459. Dia kata liquidator shall make up an account. So maksudnya dia kena prepare an account showing how the winding up has been conducted and how the company has how the asset of the company has been disposed of, should be. And then the account will be laid before the final meeting. So that means dia panggil dia punya creditors, the members of the company, the contributors of the company in order to macam to report lah the whole process. Okay, and then before the aim of the final meeting is to dissolve the company itself. And then the relevant accounts and report or return from the final meeting must be lodged with the ROC. So then the process, the company will be ended. That is dissolved, dipanggil. The company is deemed to be dissolved 3 months after the filing of the return. Okay, so actually for the members voluntary winding up, it is macam straightforward. Dia tak adalah banyak sangat isu tentang compared to the compulsory winding up and the macam creditors voluntary winding up. Okay, so that is the first one. Okay, as to the creditors voluntary winding up, so dia lebih kat mana tadi? Okay, dia lebih kompleks sikit lah compared to the others. Tapi proses dia sama. That is, dia akan conduct the whole things yang macam dekat voluntary winding up tadi. Dan the end process will be the final meeting and the company will be dissolved. Okay, kita tengok ayat ni dia kata following the EGM, extra ordinary general meeting and the creditors meeting, the appointed liquidator shall need to deal with the relevant reporting and notification requirement. So that is to lodge the special resolution. Special resolution tu yang resolution for the winding up, which is achieved at the company's meeting for the purpose of the voluntary winding up. Okay, so what need to be done is to lodge the special resolution with the CCM, ROC. Okay, dan kemudian notice in newspaper. Okay, insert the word in liquidation to company's name on every letter or invoice. So any communication made has to to communicate ataupun to inform the other party that the company is in liquidation. Sebab tu banyak dalam kes-kes kita nampak the company in liquidation kan. Okay, so that is to make other people aware that the company is in liquidation. So any transaction tu dia tak lama lah, maksudnya dia tak ada commitment further yang boleh buat apart from that transaction. Okay, and then taking control of the company's asset and transfer them into his name as liquidator, change banking signature, close current account and open new account. Ini liquidator lah yang kena buat. Okay, and then to realise company's asset, pay off creditors in accordance with priority provided by the law. Okay, priority provided by the law tu kita tengok kemudian. And then to convene a general meeting of the company and the creditors if the liquidation process takes more than 1 year. Okay, and then the last one is final meeting. So sama dengan yang members voluntary winding up tadi kan. Okay, cuma dia punya proses yang dekat sini tu lebih besar, lebih kompleks sikit. Okay, and then for the final meeting, this is the process yang bila semua proses sudah habis baru dibuat final meeting. Once the liquidator has realised the asset and distributed proceed accordingly and has obtained clearance of settlement from the relevant statutory bodies. For example, IRB ni LHDN kita lah, Lembaga Hasil Dalam Negeri. Semua tax dah bayar, apa semua lah, semua hutang semua dah bayar. Okay, and then he will prepare a final account to show how the liquidation has been carried out and asset disposed of. So the account will be tabled in the meeting, and then the returns and statement from the meeting will be lodged with the ROC Registrar of Company within 1 month from the date of the meeting. Okay, and then the company is deemed to be dissolved within 3 months after the lodging of the document. Okay, so proses kat sini banyak macam bukan lawyers punya ni lah, bukan lawyers punya cerita lah. So basic idea, this is just for you to know what happened after the winding up. Macam proses winding up tu lawyers punya kerja. Okay, and then lepas je the company has been wound up is the liquidators punya kerja. Auditors, accountant, orang yang has professional license to do this. You just need to know how it is done. Okay, and then as to the compulsory winding up, dia occur by orders of court upon application by the liquidator. So after the company has been wound up, okay, all of the process must be conducted by the liquidator. Okay, and then at the end process, the liquidator will apply to the court for the dissolution. So dia berbeza dengan yang members voluntary winding up. So in which the final process will be by final meeting. Okay, and then dia punya resolution from the final meeting tu is to be lodged in the ROC. Tapi yang untuk compulsory winding up is the court to dissolve. Okay. So kat sini the application for dissolution may be made if he has realised all of the property of the company. Okay, ada soalan ke? Okay, distributed a final dividend. So maksudnya bila semua proses dah habis, dah bayar dekat company, dekat creditors apa semua, baru dia boleh buat application for dissolution. Okay, so that is for compulsory winding up. Yeah. Okay, so that's it untuk yang process of liquidation subsequent to winding up. Okay, ada soalan ke? Okay, boleh? Yeah, okay, so that is for liquidation process. Sikit je sebenarnya yang tu. So basic idea is that kalau voluntary winding up, the process is the investigation, apa semua, recovery, kemudian the payment of the of the debt of those who are creditors of the company, semualah yang yang in which who the company is indebted to according to the priority under the law. Okay, and then at last the final meeting will be conducted. Okay, and then the resolution achieved in the final meeting will be lodged in the ROC. Kalau on the part of the compulsory winding up, so the company liquidator will have to apply to the court to dissolve the company after all of the process has been undertaken. Yeah? Okay, so that is the process for liquidation. Okay, so kita tengok sikit tentang liquidator. Siapa liquidator? Yeah. So yang ni boleh kata macam dia punya role lah. Ya. So kita tengok sikit je untuk yang ni. Who are the liquidators? For you to know lah who are they. He is the person appointed to manage the liquidation process of a company. Primary function dia adalah to manage lah the liquidation process. That is to wind up the company by distributing the asset to the creditors and the balance asset, if any, to the members of the company. The powers of the director of the company cease and all matters are taken over by the liquidator immediately upon the commencement date of the company's winding up. Okay, and then it is the duty of the liquidator to ensure that the company is completely dissolved. So that is, yang ni sebenarnya dah ulangan sebenarnya daripada yang sebelum ni kan. So kita just zero in to the liquidator. So how the appointment is made? So dalam proses compulsory winding up tu kita dah tengok sebenarnya. So that is kalau yang members voluntary winding up tu, so dia ada meeting kan. Dalam meeting in order to resolve for the winding up of the company. So the meeting tu akan appoint the interim liquidator. Tapi kalau dalam creditors voluntary winding up, proses untuk creditors voluntary winding up, so the interim liquidator may be appointed by the directors of the company. Tapi kalau lepas meeting untuk resolve for the winding up of the company, so they can appoint their own liquidators. The creditors can appoint their own liquidator of their choice. Okay, so basic idea tentang appointment tu sebenarnya kita cover dalam proses of the winding up itself. Kalau compulsory winding up is the court. Biasanya parties will suggest lah siapa the liquidator, and then the court will make order for the appointment of the liquidator. Okay, kita tengok summary saja sebab benda ni ulangan saja. Okay, so effect of the appointment of liquidator is that sama dengan commencement of the winding up tadilah, that is all powers of the director cease. So except with the consent or sanction of the liquidators, certain areas in which the liquidator feel that the director should do this. For example, certain areas only the directors know what is best for the interest of the company, then the liquidator may allow for the directors to function in certain areas. Okay, so that is the effect of the appointment of liquidator. Okay, dan dalam proses creditors voluntary winding up, kita we also have talk about interim liquidator, ataupun ada buku-buku yang guna perkataan provisional liquidator, tapi dalam Companies Act dia guna perkataan interim liquidator. Okay, so if it is appointed dalam proses voluntary winding up, then it will continue until a new liquidator has been appointed. Okay, so that is about mungkin tentang explanation saja kat sini sebab kita cover dah kat sini. Okay, siapa dia yang boleh dilantik sebagai liquidator? So the person must be an approved liquidator. Sama macam kita punya yang lawyers jugalah, must be a qualified person kan. Yang ni perkataan yang diguna adalah approved liquidator. Approved liquidator is a professional who is approved under Section 433. Yeah. Approval as a liquidator involves the Minister of Finance, being satisfied with the experience and capacity of the applicant. So biasanya orang yang ada experience yang biasanya kalau macam auditor tu dah certain time period dah dia jadi auditor, accountant for example, then they boleh apply to become an approved liquidator. The person is known as insolvency practitioner. They are usually qualified as lawyers, accountants, bankers and other professionals who have extensive practical experience in insolvency and restructuring work. So yang macam selalu juga kita refer pada Lee Shih tu kan, dia lawyers dan dia juga adalah insolvency practitioner. Okay, who could not be appointed as liquidator? Ni disqualification lah, sama dengan kita punya yang a qualified person tu yang tak boleh jadi lawyers contohnya. A person who is not an approved liquidator, a person who is inducted to the company, creditors of the company, mungkin dia bagi pinjam dia ada hutang ataupun company tu yang berhutang dengan dia tak boleh jadi liquidators. Okay, officer of the company tak boleh juga, a partner, an employer or an employee of the company, orang yang ada interest over the company tu memang tak boleh jadi liquidator. A person who is at judge bankrupt, a person who assigned his estate for the benefit of his creditors. Contohnya macam orang yang mungkin contributory ataupun members of the company tu cannot be liquidator. Okay, and then a person who is convicted of an offence involving fraud or dishonesty could not also be appointed as the liquidator. Okay, so that is about liquidator. Yang ni kita bercakap tentang removal, how a person can be removed ataupun mungkin ada disagreement lah as to the appointment of a person as a creditor. So there is a process to do that. Mungkin ada challenge, for example, a person mungkin suddenly found out to be a person having interest over the company kan. So in such a situation, the law provide for the removal ataupun resignation on his own option to be for the liquidator to be other liquidator to be appointed. Okay, tentang gaji kita tak tengok sangat lah tentang gaji. So basically it's about it will be taken, the remuneration of the liquidator will be taken from the asset of the company. Okay, so this is general function of liquidator. So kita dah cover dah tadi kan, to take possession of the company's asset, to conduct an impartial investigation of the company asset, to bring legal action, so on so forth. Panjang sebenarnya dia punya function ni, yang ni yang saya ambil yang generally saja. Okay, so the powers of liquidator is specified under the 11th schedule and 12th schedule for compulsory winding up. So it's macam dia punya list tu is long. So if a person is appointed as a liquidator, so he's obliged to macam to refer to the laws lah as regard to the powers of the ataupun the powers ataupun anything that he can do under the law. Okay, so yang ni saya ambil extract sajalah dalam 12th schedule. Example the liquidator boleh buat apa, so tak perlu tengok detail pun lah. Okay, so yang ni the main duty dia is under section 452. Basic idea is sama macam yang bankruptcy, DJI under bankruptcy juga. Dia kata the property of company on its winding up shall be applied equally in satisfaction of its liabilities and shall, subject to that application, be distributed among the members according to their rights and interests in the company unless the constitution otherwise provides. Okay, so this is the main function of the liquidator in managing the liquidation process. Okay, so saya tak nak pergi in detail sangat tentang yang ni lah. Okay, so that is about liquidator. Okay, any question? Tak ada soalan, okay. Boleh follow ke? Saya cepat sangat ke? Okay, last kali saya nak tengok tentang application of company's asset. Ya. Okay. Saya nak satu lagi sekejap. Okay, ni. Okay, so application of company's asset ni more or less similar to those that we have covered for the bankruptcy. Ya, dia ada ranking of priority as to who to be paid first. Ya. So kalau ada contoh macam bayar hutang DJI dulu kan, bayar cost DJI dulu, kemudian at last baru unsecured creditors. Ya, kita tengok cepat-cepat je lah benda ni sebab dia sama. Ya. Okay, so yang tadi section 452, basic idea is that the payment tu ataupun the payment of the debt tu shall be made according to the to the law, that is it will be applied equally in satisfaction of its liability. So maksudnya hutang tu kena bayar lah. Yeah? And then it is subject to the rights and interests of the maksudnya payment of the debt tu must be according to the application to the order of the priority. Okay, and then kalau ada balance will be distributed among the members according to their rights and interests in the company. Yeah? Okay, so basic principle daripada section 452 is that the company's property is to be applied pari passu. So maksudnya setiap rank tu dia kena bayar sama. Contoh kalau jumlah dia cukup nak bayar 20% je, dia bayar 20% for each of the person in the same rank. Ya, sama dengan bankruptcy. Ya, so kita tengok cepat-cepat je lah ya, sebab benda ni sama. Okay, surplus kalau ada will be distributed to the members. Ya. Okay. Dia ada dua situation, remember, kalau untuk members voluntary winding up tu is the situation in which the company is able to pay its debt. Yeah, so in this situation semua orang akan dapatlah dia punya share, dia punya creditors tu akan dibayar dan members akan dapat dia punya lebihan tu akan ada untuk bayar members. Tapi kalau company is insolvent, so there are people macam unsecured creditors lah yang selalunya atau dan members jugalah yang tak dapat dia punya rights which is actually common under the situation. Yeah? Okay, so this is the two situation. So I think you can see sama dengan bankruptcy juga. So ada situation contohnya bila orang tu sakit, contohnya mungkin memang dah tak ada harta, contohnya the person can be released even though not all debts have been fulfilled. Yeah? Okay, so that is how it is lah, is the reality of it. Yeah? Okay, the secured creditors tu will not be affected. Dia boleh realise dia punya security sama dengan bankruptcy juga. Okay. Okay, yang ni pun exactly sama dengan bankruptcy juga. So saya tak pergi kita tak payah ulang balik lah. You can read later. Yeah, sama secured creditors dia boleh realise dia punya property tu. So kalau ada untuk bayar hutang dia, contohnya kalau cover 100% dia boleh dia settle everything. Tapi kalau ada lebihan dia kena bayar balik kepada company tu. Okay, so that's basic idea lah. Okay, okay. So remember when a company is wound up, all of the proceeding stop. Kalau ada macam enforcement of judgment has to stop. So the way to deal with this is by way of claiming to the liquidator. That is to file the proof of debt. Yang ni pun sama dengan bankruptcy. That is semua creditors kena filekan the document that we call it as proof of debt in order for the liquidators to accept, okay, dan juga masukkan sebagai part of the people to be paid, in the process of the distribution of the debt. Okay, so sama je, cuma dia punya provision je berbeza, dia punya dia punya provision, the number of the provision is different, tapi dia punya content tu is similar with the bankruptcy. Okay, boleh, any question about proof of debt? Remember, bankruptcy pun kena filekan proof of debt, ada creditors kan? Boleh? Ya? Yeah? Okay, so yang ni pun sama juga. What debts provable in winding up adalah sama dengan debts provable in winding up. That is all debts and liabilities present or future, certain or contingent. So maksudnya mungkin the debts tu is to be paid by the company mungkin next year ataupun mungkin dalam tempoh every month until next year for example. So it's future lah. Okay, this is still to be proven by way of proof of debt. Okay. Apa yang tak provable? Unliquidated damages. For example, macam kalau ada mungkin workers, personal injury for example. A person suffered personal injury due to the act of the company. Mungkin the employee of the company mungkin dia bawa lori company tu kemudian mungkin met with an accident and then cause injury to another person, that another person tu boleh claim against the company. So tapi this is not claimable through proof of debt. So sebab dia masih unliquidated damages. So this is not to be provable by way of winding up. Okay. Okay, so how to prove it is by way of filing affidavit. Affidavit provided under section 525. Sama dengan bankruptcy juga. So that is ada form dalam rules tu in which you have to fill in order to explain what debt is, so how much, okay, and then to give evidence as to the amount. Contohnya kalau macam goods sold and delivered, contohnya macam kalau supplier hantar barang kepada company tu kan dia ada dokumen kan, ada invoice, ada delivery order, semua dokumen-dokumen tu must be attached together with the affidavit. So maksudnya kita prove the debt owed by the company to the creditor. Okay, so this is important part to be done on the part of the creditors, to claim the debt so that the creditors will be paid through the liquidation process. Okay. Okay, so bila dia dapat, the liquidator's role upon receipt of proof of debt, so upon receipt of the proof, the liquidator's primary function is to assess the proof of debt lodged with him. So dia akan tengoklah affidavit tu, so dia punya dokumen cukup tak untuk support dia punya debt. Okay, and then so if it is sufficient, so then dia boleh admit the claim. So his statutory duty is to admit all real claims to prove. So dia tak bolehlah terima je proof of debt yang tak ada, orang kata tak ada evidence. Maksudnya dia kata mungkin there is a affidavit which claim which claim that the company is indebted to the creditor, tapi there is no sufficient proof to that. So in such a situation dia boleh tolak lah the POD. Dia panggil POD selalunya, proof of debt. Okay, the liquidator may at any time call for the production of vouchers or book of account. So dia boleh call for further evidence to be supplied for the proof of debt. Okay, so that is the POD. Okay, order of application of asset ni sama dengan bankruptcy juga. First is secured creditors, okay, then preferred creditors, unsecured creditors. Okay, tapi kalau dalam winding up ni dia ada members of the company. Okay, kalau yang bankruptcy tu last dia adalah unsecured creditors kan. Okay. So dia punya ni pun sama juga. That is untuk preferred creditors ada cost and expenses of the DGI kan, remember winding up kat sini. So that is liquidator, ambil dululah. Kemudian salary of the employees, workers compensation, the tax, the contribution, dia dah turun kat sini. Okay, remuneration in respect of vacation leave. Yang ni semua workers punya entitlement. Okay, the contribution to EPF, SOCSO, workers punya entitlement as well. Okay, and then taxes. Tax, that is tax to be paid lah. Contohnya macam LHDN, business tax. Mungkin ada quit rent for example to be paid. So yang tu considered as preferred creditors. Kita tak pergi satu-satu lah. Yang ni sama dengan bankruptcy exactly. Okay, and then rank of priority tu dia kata pari passu. Pari passu tu maksudnya dia kalau ada contohnya semua 6 contoh macam workers compensation mungkin so kan, so tu macam social security, apa dia EPF contohnya yang company tak bayar lagi gaji contohnya, so dia akan kira tu sebagai equal, sama. So, contohnya kalau asset of the company tu is sufficient to pay only 60% of all, so dia akan bayar semua sama according to the proportion. Yang tu yang kita panggil sebagai pari passu. Okay. Dalam section 5 to 7 dia kata insured where a person has been injured by the act of the company and the company is insured against such liability. The injured party is entitled to be paid out of the insurance money in priority of all other creditors, including the preferred creditors. Okay, so yang ni situation in which the company take insurance kan. Insurance contohnya macam satu bangunan, bangunan mungkin company to pay for the insurance of the any losses, any macam injury for example suffered by anyone in the building tu. So dia take out the insurance. So insurance tu money bila ada seorang tu macam mungkin cedera in the building. So insurance money tu is part of the asset of the company. So tapi the asset of the company yang duit daripada insurance tu must be paid to the person who is injured out of the insurance coverage tu. So maksudnya dia akan ada priority over any other preferred creditors even. Yeah? Okay, you got this? So I think this is common sense as well. So yang mana contohnya insurance tu cover for a particular loss kan. So bila ada duit insurance tu kenalah bayar untuk particular loss yang suffered by someone else tu. Yeah? Okay, so that is there is a express provision under the law that this take priority over preferred creditors. Yeah? Dia tak bolehlah pula ambil duit insurance tu nanti bayar orang lain pula lah. Yeah? Okay. Okay, and then the last person as usual sama dengan bankruptcy is that the unsecured creditors take last. Yeah, the last cake portion of the cake tu will be taken by the unsecured creditors. Yeah. So kalau cukup dia akan bayar semua, kalau tak cukup dia akan bayar pari passu equally. Yeah. So mungkin percentage mungkin cukup bayar 80% je, dia akan bayar 80% je. Yeah. And then the last one, kalau ada balance, will be paid to the members of the company. According to the entitlement of the members as stated in the memorandum and article of the company. Semua dia kena patah balik lah untuk on the part of the liquidator tu, dia kena baca lah balik semua memorandum and article of the company to know the rights and liabilities of the all people who are involved in the liquidation process. Okay, so that's it untuk kita punya application of the application tu maksudnya proses bayaran tu kepada orang-orang yang berhak lah ke atasnya. Okay, so that's it for the topic. Kita cover 3 topik, saya tengok goals tu tadi balik. Okay, kita cover yang tadi tu commencement of winding up. It talks about the point of time when the winding up commence. Okay, and then what is the effect of it? Ada 7 effect tadi kan. Cease of the cease of the director's power, cease of the business of the company, so on so forth. Okay, then apa yang berlaku dalam liquidation process? Kita talk about the second one tadi. Okay, then who is the liquidator? Okay, and then how the company's asset is to be paid to the creditors, according to the rank of the priority provided by the law. So at the end of the process, the company is dissolved. So that's the end of the life of the company lah. Alright, so that's it for the topic of winding up. So kita akan tunggu, saya akan tunggu yang Cik Azmi untuk habiskan compulsory winding up. Dan mana yang adalah saya rasa macam cases tu mungkin dia tak cover tu, yang tu saya cover next week lah. Saya rasa tak banyak lah dah. Okay, so for the purpose of last assignment, nanti saya masukkan instruction dia. So basic idea is that I would like you to prepare macam study balik yang Cik Azmi sampaikan tu, daripada proses statutory demand sampai filing petition apa semua tu kan, sampai affidavit, sampai ke advertisement apa semua, dan sampai order of the court tu, saya nak minta macam sediakan infographic as to the whole process. Yang ni individual job. Boleh tak? Yang tu last kali untuk winding up process. Dan saya nak minta masukkan semua macam contoh bukan saja macam general idea tentang dia punya proses daripada contoh macam statutory demand, petition, affidavit dan proses iklan tu semua kan, advertisement, apa dia proses dia sampai ke winding up tu. Dan saya nak masukkan dia punya provision sekali. Provision which is provided under the Companies Act, okay, and then the companies winding up rules. Ya? Yeah? Boleh? So nanti saya letak dia punya instruction. So this is individual assignment. Saya masih belum bagi respons lagi tentang tentang yang bankruptcy tu kan. So agak macam tight juga sikit sekarang, macam Cik Arif pun tak berapa sihat lagi. So macam masa tu agak tight juga. Saya cuba dalam tempoh sebelum end of the semester I will try to respond to all of you macam as to your marks. Okay, and then saya akan bagi common mistake. Ada jugalah yang saya jot down the common mistakes that when I check your assignment so far. Yeah? Okay, so that would be yang assignment on winding up process tu would be the last assignment before kita punya final examination. Final examination tu purely on the will focus on the winding up only. Yeah? Okay, so ada soalan yang daripada Atika. Is there any safeguard for the liquidator so that they don't secretly take the company asset or money as all the property is transferred to them? Okay. So I think safeguard dia sama macam lawyers jugalah ya, dia punya proses, dia are subject to a professional, they are macam regulated by professional body lah kalau mungkin. Dia are professional, so professional ni dia tertakluk kepada dia punya etik, ya, professional etik. Okay, and then dia ada juga disciplinary process lah. So macam sama dengan kedudukan lawyers jugalah, walaupun kita ada etik kita juga kan, tapi adalah situation yang berlaku kan, banyak juga lawyers yang apa orang kata commit ataupun convicted of breach of trust kan. So it happened in the real life, walaupun kita ada semua tu, tapi that is actually the safeguard under the law. That is, the liquidator is a professional person who is regulated by a professional body dan dia tertakluk kepada etik, professional etik. Okay, then kalau ada complaint against them, so dia boleh cause dia punya professionalism tu, dia punya kerja pun boleh boleh boleh, dia punya license tu can be taken. Okay, so that is a kind of safeguard, I think, if I could answer your question there. Yeah, Atika, boleh? So sama macam dengan peguam juga kan. Contohnya bila seller and purchaser for example, bila dia bayar duit, dia kan bayar duit dekat peguam kan, dan peguam akan simpan duit tu sampai end of the process, dia akan release dia punya deposit tu. Okay, so in that situation it happen actually for them to deal with this. Okay, another safeguard I could think of is the account. Yeah, the account which must be put up to the final meeting. So bila proses tu dijalankan daripada awal, winding up process to commence. Okay, and then the process of macam investigation, realization of the property. So at the end of the process, the account must be put up to the final meeting. Okay, and then this is subject to investigation ataupun bukan investigation lah, subject to kita panggil macam observation ataupun apa perkataan yang lebih tepat dia untuk the whole account of the company to be deliberated by all people who are interested with the ataupun ada interest over the company. That is macam the members of the company, the creditors of the company are able to access the account of the company to ensure that the process to is conducted properly. So that is another safeguard that is provided by the law, yeah, that I could think of as well. Yeah. Okay, boleh Atika, do I answer your question?
Okay, madam. Thank you. Clear.
Alright, you're welcome. Thank you for the question as well. Okay, so mungkin cepat-cepat jugalah kita habiskan. Kita habislah dah ya topik winding up tu. So I hope you can go through the provision as well, and we'll meet again tonight. Yeah, so I hope Cik Azmi boleh finish the topic of compulsory winding up tonight. Yeah, alright. Okay, alright. So thank you so much. Yeah, for today. Saya simpan. Okay. Saya simpan ni macam ni kan. Okay, copied nanti dalam ni kan. Okay. So thank you so much. Saya rasa tadi Atika ke Amirah yang bagi tahu saya upload the wrong video yang Cik Azmi punya tu kan. Nanti saya cari balik dalam Zoom punya dokumen tu. Saya mungkin silap. Sebab sebelum ni saya nampak satu dokumen saja. Saya upload dokumen yang salah. Dalam goals tu, the video Cik Azmi tu. Ya. Yeah? Okay, thank you so much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Okay, so saya stop recording and I end the meeting. Yeah?